calling the Planning Commission meeting of May 23rd, 2022 to order. If we could rise and pledge the flag, please. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, God, indivisible, with liberty and justice for all. Thank you. The first item on our agenda is the call to order and a roll call. So, Vice Chair Heath?
Here.
Excellent. Mr. Crockett?
Here.
Commissioner Crockett? Commissioner Dawson?
Here.
Commissioner Derby?
Here.
Commissioner Havel?
Here.
Chair Tiernan. And let the record show that Mr. Gerber, Commissioner Gerber, is not currently present. Approval of the agenda. If I can get a motion on this agenda.
So moved. Second.
Okay, I'll take a roll call on that. So I'll start from my right. Commissioner Dawson?
Aye.
Commissioner Havel?
Aye.
Commissioner Heath?
Aye.
Commissioner Crockett?
Aye.
Commissioner Derby?
Aye.
And Commissioner Tiernan votes aye as well. Public comment. So at this point, we have an open mic for issues that aren't before us. We have two items before us. One is the CIP authorization, and then 560 Trumbull. Is there anybody that's online that wants to talk to us?
So if you're joining us online through Zoom, if you'd like to use the raise hand function to address the commission on a non-agenda item, now's the time to do it. I am not seeing a hand up for the three attendees.
Okay, that's great. So we do have a little bit of unfinished business. We have some minutes, and I will say in advance that it was a meeting I did not attend, but I'll entertain a motion to approve those minutes.
I'd like to make a few modifications if I could before we make a motion.
Let's proceed with that. What changes?
So on page 4 of the packet, in the item that was being discussed that night, there's a statement from Planning Manager Marshall, and it's Mr. Marshall responding to concerns that the project wasn't properly noticed. And in the minutes, it talks about that the project was noticed and that the commenter was outside of the noticing radius, and that's where the minutes stop. But Mr. Marshall also went on to say that the project was posted online and that it was posted, per all the legal requirements, and so I'm sorry, I'm looking for the language right now of. So what it said was Planning Manager Marshall explained that Hamilton was well beyond the notice area required for the proposed amendments. What I think it should read to say is Planning Manager Marshall explained that Hamilton was beyond the codified noticing radius required for the proposed amendments. Additionally, Planning Manager Marshall noted that the project had been posted to the city's website at www.novato.org, and a public notice had been posted online and in the Marin Independent Journal. And then on that same page, there's a statement from me, and it says, there's one sentence that says, he, meaning me, stated Novato is uniquely situated to support expanded life science. That should read uniquely situated. Those are my only modifications.
Okay.
If it should please the commission.
Any other additions or amendments that commissioners want to make? Okay. Staff got those changes?
We do.
Oh, excellent. Okay. So I'll entertain a motion with those corrections to approve the minutes as presented.
So moved.
Good.
Second.
Okay. So Commissioner Dawson?
Aye.
Commissioner Havel?
Aye.
Commissioner Heath?
Aye.
Commissioner Crockett?
Aye.
Commissioner Derby?
Aye.
And Tiernan was absent, so I'll be abstaining. So the item that's before us tonight is a lot split. It's the Lock Urban lot split at 560 Trumbull Avenue. We're going to conduct a public hearing, consider the appeal to the Community Development Director's rejection of an application for that urban lot split. determined that said application is incomplete related to two proposed subdivisions of property located at 560 Trumbull. With that, I'll turn it over to staff to get this moving.
Good evening. Brett Walker, Senior Planner with the Planning Division. So this item is a public hearing and consideration of an appeal by the applicant, Kathy Locke, of the Community Development Director's decisions regarding a recently submitted application to subdivide a lot utilizing the process commonly referred to as SB-9 Urban Lot Split Parcel Map. This evening, the Planning Commission is tasked with two items. First, to consider whether the city appropriately rejected the application based on codified processes when zoning violations are identified at the site. And second, whether the city appropriately deemed the application incomplete. So the applicant filed the SB-9 application on February 16, 2022. The city initially deemed the application incomplete on March 17, 2022, and subsequently, the applicant resubmitted on March 25th, 2022. And after that, the city deemed the application incomplete for a second time and also decided to reject the application due to outstanding zoning violations at the site. The city determined that the zoning code violations need to be resolved before the city can consider a decision regarding the SB-9 parcel map application. So first on the rejection. So Novato Municipal Code, section 19.40.070, subsection B2, states that the director shall reject and not process an application if conditions exist on the site in violation of the zoning ordinance. During a review of the application, Planning Division staff identified existing zoning code violations that have not been remedied. The zoning violations were detailed first in the first incomplete letter dated March 17th, 2022. The March 25th application resubmittal included no reference to the zoning violations and only attempted to address the SB-9 completeness items. Since there was no attempt by the applicant to remedy the zoning violations, staff determined that rejecting the application was necessary for compliance with the city's zoning code. Since the applicant had not go through the process to remedy the zoning code violation, staff believes that rejecting the application until said violations are remedied is consistent with the zoning code. So this shows the project site, and I've got two aerial images taken from Google Earth. The slide on the left is from 2017, and you'll notice in the upper left corner of the property a water feature. It's a little bit green tinged in this image, and then you'll also notice quite a bit of vegetation in that vicinity of that water feature. And then we've got a second image from 2021, February 25th, 2021. And that is basically showing the same property with most of that area in the upper portion of the lot filled in with fill material and some other improvements within that area. This is a zoomed in shot of that previous image from 2021 that gives you a little bit better idea of the amount of fill and changes that have been done to the property compared to the 2017 image. Additionally, got some images from when code enforcement went out to the site. These images are dated February 12th, 2020, around 10:57, 10:58 a.m. From the front gate, you can see quite a bit of dirt. The area to the left, I believe, would be the area in question that previously had the pond area. The image on the right, I'm not 100%, oh, I do believe that this is, you can see the area that's in the image on the right, sort of in the center of the picture on the image of the left. If you just focus on that center area, there's a pile of dirt in and around some trees. Here's a couple more pictures. Picture on the left shows a heavily reduced drainage feature. It's basically a narrow drainage feature at this point. And then the image on the right is just to show some additional fill. Looks like, without having been there, it looks like maybe there's quite a bit of fill added that is up along the trunk of the tree, where I would presume the tree trunk was at a lower grade prior to that image. So next up we have the Stream Protection Management Plan. And for this one, I'm going to go to a PDF image just for better clarity. So this was a stream protection and maintenance plan that was submitted to the city and approved. And I'm gonna zoom in a little bit here. Well, so I'll do a little bit explanation here. This area right here is labeled as existing pond. So you have an area here that was previously identified by applicant submitted documents in and around year 2000 associated with a pre-zoning application near and about when the property was annexed into the city. And then you've got, it's not like in the Zoom right now. And then you've got this area where it talks about drainage way also. And then there are quite a bit of notes over here related to the approval of the drainage plan. I'm going to close out of this and try to get back into it. Okay, so this Zoom worked in. So you can see a label right here that says existing pond. And then around this water feature in a dashed line, it labels that as the stream protection zone. And this label right here states, uses permitted within the stream protection zone shall be limited to native landscaping, fencing, maintenance roads, utilities, and storm drain. Fencing shall be set back to provide for unobstructed flow of flood waters and continuous wildlife migration corridors along the riparian areas. And then additionally, there are some notes on the map related to the site. Note 1 says removal of existing riparian vegetation shall be avoided to the maximum extent feasible and limited to the minimum amount necessary except for exotic invasive species or other vegetation identified in the approved SPMP. And then note number 2 says grading, fill, earthwork, or soil compaction within the stream protection zone shall be avoided or minimized to the maximum extent feasible. During construction, protective fencing shall be installed along existing riparian vegetation to include a buffer area extended beyond the drift line of the tree canopies to protect the root structure. And then it goes on to some additional information. So this was the basis of one of the identified zoning violations, was the fill of this area identified in the stream protection and maintenance plan. The second item that the city identified was a drainage management plan that the property owner at the time of this is the current property owner, went into an agreement with the city of Novato to maintain this drainage way. So that kind of concludes the identified zoning violation portion of the staff report. Next up, I'd like to get into the complete application portion of the staff report. So the incomplete letter dated April 25th, 2022 includes a list of items that staff identified as deficiencies regarding the application submittal, including reference to submittal of site-specific information regarding the presence of wetlands and or habitat for special status species. Additionally, the list included identified zoning code consistency issues regarding building setbacks that would be created by the proposed lot lines. As the staff report goes into more detail regarding both the zoning violations and completeness items, but in summary, the Community Development Director did not deny the SB-9 application as stated by the applicant in their appeal letter, and that the director rejected the application consistent with processes identified in the Novato Zoning Code due to outstanding zoning violations. And there is a distinction between rejecting an application and denying an application. Staff would also like to point out a letter that the applicant submitted to the city on May 22nd, 2000, and that should have been in front of you tonight when you got here. In that letter, there were 2 items numbered. One that states, we want to keep the pond since it is home to numerous turtles and birds. And then the second item states, we would like to provide a complete drainage plan upon completion of our house instead of holding up a building permit waiting for an engineer to be available. The following paragraph in that letter goes on to state that their intention is to clear the path for water to flow from the pond to the creek. And then a second item staff identified was from meeting minutes from a Planning Commission meeting on April 10th, 2000. And that should be in front of you also. And if you go to page 12 of the minutes, in the second paragraph, the property owner, Ms. Locke, the applicant, stated, if you go down to the middle of the paragraph, that the pond was in existence before the suburb was built, and it is an established habitat. Later in that paragraph, it states, she requested that the condition requiring the drainage management plan be modified to allow enough time to require the drainage plan. So with that, staff is recommending that the Planning Commission deny the appeal. Staff is available here to answer any questions. And present tonight is an attorney to provide legal counsel to the Planning Commission, and her name is Christy Crowell. She's not present in the meeting, but she is on the Zoom meeting. And this attorney is specifically here to provide legal counsel to the Planning Commission, as Jeff Walter, our city attorney, is present this evening to represent city staff. Also present is the applicant's attorney, Elizabeth Breckus. She is also attending the meetings via Zoom, and she'll be making a presentation on behalf of the applicant. So at this point, planning staff invites Christy Crowell to present any initial information to the Planning Commission, and then staff can complete its presentation.
So Chair Tiernan, before we move into Christie's presentation this evening, I just want to note that the correspondence that Senior Planner Walker was referring to is a May 23rd letter from Elizabeth Breckus to the Planning Commission, as well as 2 supplemental documents that were referenced, the meeting minutes of April 10th, 2000, and then a letter from Ms. Locke to the city dated May 22nd, 2000. Those documents are available in the chambers this evening if anybody from the public would like to examine them, and then we will place them into the record after this meeting.
Very good.
And with that, if we're prepared for a presentation from Attorney Crowell, I can go ahead and have her activate her microphone and address the commission.
That'd be great. Yes, let's move forward.
Thank you, and good evening, Chair Tiernan and Commissioners. My name is Christy Kroll, and I'm with the law firm of Jarvis Fay. And as your staff indicated, I was asked to review the materials related to this appeal and provide independent advice to you this evening. I would like to thank staff for their diligent work in preparing the information for this appeal tonight. And I have reviewed the staff report and supporting materials, and I just want to advise you regarding 3 specific points, which I'm going to enumerate for you first, and then I'll discuss in a little bit more detail. And the first point is that the threshold question for the commission tonight is whether SB-9 actually applies to this project. The second point is that I agree with staff that the appellant has failed to submit sufficient documentation to demonstrate that SB-9 actually does apply. And third, I ultimately agree with staff's recommendation to deny the appeal and reject the appellant's application as incomplete. So to start with that first point again, the threshold question is whether SB-9 applies to this project. And it is my legal opinion that SB-9 preempts application of Section 1940-070B2 of the Novato Municipal Code, which is what the staff report relies upon to find that the planning director can refuse to process the application. And just with all due respect to staff, I disagree that this section could be used as a reason to reject the application if this is indeed an SB-9 project, because SB-9 directs the city to ministerially approve or deny a complete application for an SB-9 project. So the city's own code provisions governing the processing of other non-SB-9 planning applications would be preempted by SB-9. But all that said, and to get to my second point, I agree with staff's ultimate recommendation to reject the appellant's SB-9 application here because the appellant has failed to submit sufficient documentation confirming that SB-9 does apply and that this is in fact an SB-9 project. As the staff report correctly indicates, SB-9 requires an applicant to demonstrate that the property does not contain any wetlands or protected habitats, and the appellant has thus far failed to do so. And again, that failure is documented well on pages 6 to 7 of your staff report. The city requested an assessment from a qualified professional, but the appellant has thus far refused to provide one. So the city can't confirm that there are no wetlands or protected habitats on the property. And moreover, as Mr. Walker just noted in his presentation, the city possesses conflicting evidence indicating the presence of a pond and certain species on the property. And finally, just to highlight my third point, I think it would be appropriate for the commission to deny the appeal this evening, consistent with staff's recommendation, just given that the SB-9 project application is not complete. So I would advise that if the commission is going to adopt the resolution denying the appeal that's included in your packet, that you would propose to adopt it without findings 1 and 2 under Section 4, because those sections detail other potentially problematic reasons for rejecting the application. And I understand that my advice differs slightly from what's included in the staff report and the planning department's presentation. So while this kind of concludes my advice to you on the item, I'm here to answer any questions now or as they may arise during your discussion. I also realize this is funny that I'm not there in person and I feel a little bit like the Wizard of Oz, but please don't hesitate to ask me any questions should any come up during the meeting.
Oh, okay, I appreciate that. And it's Ms. Krull, right?
Kroll, yes.
Kroll. Okay, so first let's, if there's any questions from the commissioners about what you heard from the staff or from Ms. Krull, before we move on to the applicant and listen to what they have to say. Commissioner Dawson.
Yeah, as it relates to, I mean, part of the basis for this is that there was not documentation provided as to the whether there are wetlands present on the site or not. Presumably, based on the pictures that have been shown, if somebody went out there, there's probably not wetlands there. So how does the unpermitted work that appears to have filled in the wetlands relate to, trying to make a wetlands determination?
That's a very good question because the site has been disturbed from what it used to be. So it likely would be difficult to make a determination as to the extent of the resource there, basically the water feature, and the presence of by definition, of a wetland. We haven't discussed that internally, and I don't think we've came to a decision on how the applicant could provide sufficient evidence regarding lack of wetlands at the site or previous presence of wetlands.
Well, I mean, it would certainly appear that there were wetlands there. And normally filling in wetlands is frowned upon by a number of regulatory agencies. So how does that fold into this, if at all?
Just to jump in, I would just say that the threshold question for the commission tonight is whether the application was complete or not and whether SB-9 applies. So in the event that the applicant can and does present evidence sufficient to complete their application, then I think that it would come back. It could potentially come back to the Planning Commission. But at this point tonight, the question is whether the applicant has submitted evidence to staff to get a complete application. And if not, then staff, properly rejected the application as incomplete.
Mr. Walters, you wanted to add something?
Yes, if I might, this is Jeff Walter for the record. Tonight, our firm is representing the planning staff. In large part, that is due to the fact that our firm is representing the city in litigation that's been brought by Ms. Locke. And we're in an adversarial role with her counsel and with her. And we believed it was appropriate then to separate the legal function between the commission and the staff. And that's why outside counsel has been asked to come in and to advise the commission. And I agree with Ms. Kroll's comments. Right now, the question is there sufficient information in the application for the staff and this commission to determine whether or not SB-9 applies? SB-9 has a list of the types of properties that are ineligible to be treated under SB-9. And one of those types of properties is a property that has wetlands or has endangered habitat. Ms. Breckus argues in her first submittal that the burden is on the city to prove that there are such features and conditions of the property. That's not her client's burden. We believe that that's a wrong legal opinion and disagree with it strongly. As a practical matter, if it's the city's burden, we would need to have permission to go onto the property. Her client could decline that permission. And thus the burden would be unmeetable, unsatisfiable at the instance of Ms. Locke herself. That's one of the reasons why that concept doesn't really work here. The question, though, is does the information in a packet give the staff and this commission enough information to decide whether there are these features on the property. And we maintain that there's insufficient information to come to that conclusion. That's really all you need to address tonight. Let's assume for the moment that Ms. Locke, the commission agrees with the staff, and Ms. Locke then goes back, hires a professional to do the assessment, and the assessment comes forward with a conclusion that there are no wetlands and there are no endangered species on the property. That will then require the city to decide what it needs to do to marshal evidence that might be contrary to that. The burden, I think, would then shift. We would have to come up with some contrary evidence that at some point in the history of this property, those features were there. But that's a bridge we have yet to cross, and we do not need to cross that tonight.
Did that get you close to an answer?
Sure.
Any other questions?
Sure. Yeah, I'll just jump in. So back to the threshold. So I mean, one of the cases, and by the way, thank you, staff, for a very, very thorough report. There's a lot in here. Yes. You really walked us through your narrative. But hearing from Ms. Crowell that she disagrees with the threshold question, right, whether or not SB-9 applies here, that's throwing me off a little bit because you made a very compelling argument. And in fact, you were stating that because there's a existing violation on the project, you cannot accept the application. Is that something that's stated in SB-9 law, or is that a city ordinance? And I guess, yeah, I'm trying to figure out why Ms. Crowell disagrees with what I thought was well worded in the documents.
Maybe Ms. Crowell, you could respond to that question.
Yeah, I'm happy to answer that, Commissioner Derby. So while staff and I get to the same conclusion, we just get there in different ways. And if SB-9 applies, meaning the applicant has shown that this project could be an SB-9 project and provides sufficient evidence indicating there's no wetlands and there's no riparian habitat, then this SB-9 project would be an SB-9 project, and the city's municipal code provisions would be preempted because SB-9 is a ministerial process, and in state law, the state law requires the city to either ministerially approve or deny a complete application for an SB-9 project. It could not then apply its own municipal code provisions that separately govern planning applications that aren't SB-9 applications. So state law would simply preempt that section of the municipal code that staff has cited in the staff report and relied upon to reject the application. Either way, I concur that the application should have been rejected as incomplete. I just disagree with use of that provision in your municipal code to get to that result. Does that make sense?
Yes, it makes sense how you came to your conclusion. Thank you.
Anything you wanted to add? No? Okay.
Yeah. I kind of wanted to follow up on that if I could. So just more to understand. So if I've got a property and I go full cowboy and start building on it, and then I come in and I say, well, actually, I want to subdivide it. So I built a couple of structures out there. Nothing's permitted. I'm just going for it. And then I say, oh, I want to do this ministerial permit process. Is that, so what you're saying is now I can get permits for that, and that provision in the city ordinance that says you need to rectify those code violations before you get permits for something else, that doesn't apply? Ms. Wizard, are you there?
The provision that's cited in the staff report, it has to do with processing, and it says the staff doesn't have to process an application with zoning violations, where zoning violations exist on the property. And I'm saying that SB-9 requires different processing requirements. It has ministerial approval, right? If an application is fully complete, you either have to deny on the merits or accept, or approve the project on the merits. And that section that is cited in the staff report, 1940-070B2, is a processing section that's preempted by SB-9. So I can't really answer your hypothetical kind of in a vacuum, but I can say that this section would be preempted in this case if this is an SB-9 project.
And I think another way of putting that, assuming that Ms. Carl is correct in her interpretation interpretation of SB-9 and how it operates to preempt the city's own zoning code provision requiring rejection of any land use application where the property is subject to a zoning violation. Is that the remedies available to the city to correct these zoning violations is not affected by the opinion that Ms. Crowell is articulating tonight. The city can independently pursue code violation actions against this property owner who's impermissibly built two structures. And it's my opinion too that, and Steve and I have talked about this extensively, the SB-9's amended two sections of the government code. One section was the Subdivision Map Act, and that's the section that's governing tonight's meeting. They're trying to split this property in half. That's a subdivision. And the SB-9 has a specific clause in there saying that the city cannot impose as a condition of approval of a lot split the correction of non-conforming conditions on a property. And Steve Marshall and my own experience has convinced me that that is referring to legal nonconformity. So if you have a grandfathered use on your property, and that means at the time it was initiated, it was lawful, but has become unlawful due to the changes in the zoning code or other rules or general plan use designations have been modified that render now and turn that use into a non-conforming use. It's still legal, but it's non-conforming. That does not apply to illegal non-conforming uses and conditions in the property, so that if these unpermitted uses, the two structures that were built without permits in your hypothetical exist, and code enforcement has not yet taken action to take care of those unpermitted uses, under SB-9, the staff and this commission would be authorized to condition the approval of the lot split on the correction of the illegal conditions on this property. That is another way of remedying this problem. It ends up being addressed at the end of the process rather than at the beginning. Rather than rejecting the application out of hand at the beginning, it's taken care of at the end. So there are other ways to address this issue besides rejecting the application.
Okay, so Mr. Walters, if you could just stay there for a second. Without delving into the litigation, is that essentially the basis of the litigation, that code enforcement said, you know, you're red tagged, and now there's a determination how to correct that?
No. The litigation was brought primarily based upon claims that due to the city's actions, Ms. Locke's property was flooded, experienced sinkholes and other damages, and she has sued the city for over $400,000, which she claims she has spent correcting the problems caused by the city. That was the basic thrust of that litigation.
Wow, getting more complex by the moment. Okay, thank you.
Yeah.
Any other questions from the commissioners? Oh, yeah, Commissioner Crockett.
This is more of I guess, an observation that, from my personal experience of what might constitute fundamentals lacking in such an application, and that is that from everything I understand, it's well documented that there had been a pond, and the pond was a stormwater retention feature, and it predated annexation by the city. I believe that's correct. I don't see in the documentation to date that the applicant explained why they filled in the pond, why they didn't obtain a permit for that work, and how they're going to comprehensively manage the water flow on the site, all of which would typically be done before you do so much construction. So to me, that is, it's fundamental to the representation that this is not a complete application. It doesn't have a solution or rationale.
Okay.
So correct me if I'm misunderstanding that.
Would you want to add anything?
Well, your basic statement of the facts is true. The grading work began in 2020 without a permit. The city received a complaint. The city went out and put a stop work order on the work and required Ms. Locke to apply for a retroactive grading permit. She then hired an engineer, came up with plans, specs, et cetera, to the satisfaction of the city, and a retroactive grading permit for the work that she was intending to perform was granted. The facts that there existed these 2,000 conditions, these conditions imposed in 2000 by the pre-zone ordinance, a copy of which is in your packet, requiring the drainage way maintenance agreement and the stream protection plan. Those facts were not made known to the staff in 2020. A staff that wasn't there in 2000 and had no knowledge of these particular requirements, and they never were informed of these requirements. And based on that, they issued the retroactive grading permit.
Understood.
Were those not recorded against title?
It was. The agreement was recorded against title.
And that's
Still,
not something we ask for when we provide permits. We don't ask for a title report or anything like that.
I do not know the procedure when it comes to title reports.
Not typically for a grading permit, no. We had all the engineering studies. We wanted the applicant to engage with the environmental regulatory agencies. But yeah, we weren't aware that there was the that
No
20-year-old agreement. that
No
was
Alta
recorded.
survey or anything that you typically, okay.
Okay, so we've at least heard from staff. So I believe this would be Ms. Bacchus, the applicant. If you could bring her on. So
Yes, we have Elizabeth Breckus, and we have a PowerPoint presentation, so I will allow Ms. Breckus to speak now.
You recognize Ms. Bacchus?
Hi there. Good evening. Elizabeth Breckus with Breckus Law Partners, attorney representing the applicant and the appellant Kathy Locke. Can you all hear me?
Yes, ma'am. I can hear you fine. Thank you.
Thank you very much. I know you received my letter late today, and I'm sorry for that. And I also wanted to make sure that you did see that we did apologize for the fact that 2 of the planning commissioners wanted to go on to Ms. Locke's property. Unfortunately, I was out of the country and did not receive her email. And she was concerned that with the litigation, this was like a site inspection that her attorney should be present for. And so she was not sure how to respond and got the advice that she should not allow them on. And in hindsight, I wish I had coordinated that with the city attorney. Moving on to this application, I know you have a long night and I want to be respectful of that, but what have we heard so far? Well, the primary ground that the city denied this application was a rejection basis. And what you heard from the city attorney or outside counsel that the city has hired is that that was inappropriate. That conclusion was erroneous. The city cannot cite to its own municipal code and state and show that these the application can be rejected on that basis. Instead, the city's reverting to a secondary basis, which it said was not the basis it was relying on, because instead it was going to reject it. And that is a denial of the application because it is incomplete. And so right away, I think that the Planning Commission should be suspicious of the city staff's position, which is evolving, and look at the merits of this. And there's a lot of background that we haven't given to you, and we're not really sure it's appropriate in large part because this is a ministerial application. It really wouldn't even normally come to the Planning Commission. I'm not even sure that it really should be before you. What happened was in 2020, before the 2020 work that was done on the property by Ms. Locke, she began having trees that fell down, and in fact, one blocked the road and damaged her fence. She also had numerous sinkholes develop on the property that were significant and difficult to identify and correct. And yes, sinkholes do have to be filled in. That's what we do with sinkholes. And she also lost part of her driveway, so she could not drive into the building, the property. And so she actually had to correct that condition, and she hired Gelati, which is a very reputable company that does most of the work for the municipalities in the county. And then she got red tagged for not having a permit for that work. When she applied for that permit, it's not like there was a box that said, please let us know if there is any agreement between you and the city relating to your property, that she did not check or misrepresent it. Instead, she had an engineer who appropriately identified the drainage improvements as appropriate for the property. And remember, she has a drainage maintenance agreement that requires her to maintain the drainage that doesn't require the city to. So it's not as if the city would have some greater authority over her, and her engineer said it was appropriate. And the city looked at the improvements to the driveway and agreed that the after the fact permit was appropriate. Now and the city attorney referred to herself as the wizard. And then what I just heard took me into Oz, because the city attorney said she impermissibly built 2 structures. That is inaccurate. That is incorrect. All of the structures are permitted. None of them were recently built. So I just have no idea where that came from. I'd like to, if we could, go to the slide presentation that I emailed to staff. Is it possible that you can pull that up?
I believe it's currently up. It has 3 points, subdivision, 99,028.
Yeah, I can't see it. Is it possible that you can put it on so that I can also see where you are? Make sure we're in the right spot. Thank you. So the application before you subdivides a 99,282 square foot parcel into a 54,201 square foot parcel and a 45,081 square foot parcel. There is no physical development on the site proposed or included in the application. The part of the new parcel 1 proposed has an existing building on it, which is presently an art studio. It is not proposed to be developed as part of the SB-9 application. Creating the lot split creates essentially a legal fiction because there's no physical impact to the property, including the area with the disputed drainage. The April 2022 letter states that they cannot grant the SB-9 development because it would make some portion of the lot developable that is not subject to development. That's not correct. First off, the only structure that will be thereafter is a structure that already is on site, and there is no application. And again, there's no illegal construction that has been proposed. And if you could move to the next slide. The rejection for code violations is pretextual. As of this date, Locke has a valid permit for the work performed to the driveway. She has received no notice of zoning violations following issuance of the permit. The pending litigation regarding reimbursement for $400,000 in damages to Locke's property is separate from this lot split application. The city did not allege any zoning violation in that lawsuit, but instead brought a breach of contract cross complaint. Novato code purports to allow rejection of applications for zoning violations, but not for breach of contract claims. So I just want to make clear, since I don't think it was clear from staff's presentation, there has been no code enforcement action. There has been no code violation action taken against Ms. Locke. And in fact, the city properly issued an after the fact permit for a driveway, which, crossed over the line, but then got approval. And so it was only later that the city took a position that we shouldn't have done that because we didn't know about this agreement. And I'm not sure why that's on Ms. Locke. Would you please go to the next slide? We also heard from the city attorney's presentation that the city can't use its own regulations, and the staff did not understand that when reviewing this SB-9 application. The city attorney didn't mention the issue of step backs, but I think even the city attorney that has been hired to come and discuss this matter would agree and concede the city is wrong on that count as well, and the city can only follow the 4-foot setbacks that are in an SB-9 language. If you would please go to the next slide. So now we're asking you to look at this issue that the city is saying is an appropriate look, and it's the endangered species habitat and wetland habitat. And now the city attorney has said, well, maybe it's ambiguous. And so now the burden shifts back to Ms. Locke to provide that, and she hasn't. That's a new position taken, an evolving position taken by city attorney for Novato. And I'd like to point out that we've already had the attorney general opine on that issue of burden. And I don't know if you read with amusement that the city of Woodside tried to argue that they did not have to follow the housing element and RENA obligations to produce more housing because they were a wildlife habitat refuge for bobcats and wildcats. And so they were not obligated to comply. And the city attorney general responded to the city of Woodside and issues these opinions that are then used by others to interpret laws. And it said, no, that's not right. Land that is already developed with, for example, a single family home is not by definition habitat. Now I'd like to go to the issue of Ms. Locke's statement in 2000. She was going off of her prior understanding from the prior owner's map, which I think was provided and shown up on screen as a PDF, if you recall earlier. And she was at the time understanding that it was a habitat. It was only after she hired an engineer who said, this isn't a pond, this is ponding of water. And it's ponding of water because the entire subdivision up above Ms. Locke's property is drained into her property by the city of Novato's drain pipes, which make a sharp L into her property. So no, it is not a habitat, but we do know from the state attorney general's opinion that the burden is on the city to make that. And if it's an improved developed property, it is not going to be declared endangered species habitat. Would you please go to the next slide? The city has not met its burden to refute the map that we have provided showing no wetlands. We submitted reasonable evidence of the type accepted by other counties that her property is not wetland. The map identifies potential wetland areas, and 560 Trumbull is not even within a potential wetland area. No other counties do accept maps as evidence, and per the AG's letter, the burden's on the local agency to produce substantial evidence to dispute the eligibility. And there is a reason for this. SB-9 is supposed to be a quick and easy way to create subdivisions to fulfill an important urgent state need to provide more housing. And we don't want to put undue burdens on that. And so it's not appropriate for the city to say, you know, go get an EIR, go hire wildlife experts and do these things. You're allowed to submit evidence that shows it. And if the city then disagrees, it has the burden to provide the other evidence. So the other thing I just want to make clear, because I did hear it from one of the commissioners, you know, is it appropriate to grant this if someone goes off and does illegal construction and then wants to do a lot split? Does the city have no authority? And I just want to make clear as a preliminary matter how factually inopposite this situation is. In this situation, a homeowner suffered $400,000 of damage to their property as a result of not water naturally coming onto their property, but coming onto the property from a subdivision above. And I assure you that you will probably, if you incurred $400,000 of damages, you would probably retain an attorney to find out if that is your responsibility. So painting Ms. Locke as a litigious person is not really appropriate or fair. What happened was the city then got that lawsuit, and it responded by alleging that the zoning maintenance agreement was violated, and not that there were zoning violations. And so we have heard a very different story tonight as to why this should be denied in that it is not complete. But I want to remind you that what you were originally told is it needed to be rejected because it was inconsistent with the zoning regulations and there were zoning violations, and so they didn't have to process. We now have a changed position from the city, and I would invite you and encourage you to look at this very closely and see if the remaining grounds that the city attorney is stating are appropriate for you to deny this appeal are there. I urge you to grant the appeal and allow this to be a lot split. As you see, there is absolutely no change to this property other than the fact that there is a lot division of the land and no development occurring as a result of the lot split. Thank you very much. I'm here to answer any questions you might have.
Excellent, thank you. Let me poll the commission and see if there are questions.
I have a question.
Yeah, Commissioner Derby.
Sorry, Ms. It's Breckus? Yes, Ms. Breckus. So I'm sure you weren't, she's still on?
I am.
Oh, there we go. Yeah, sorry, we lost power on something. I'm assuming you weren't retained back in 2002, was it? When the agreements were, when she was annexed into the city, correct?
I'm familiar with the process that occurred back then, but no, I was not the attorney at that time.
Okay. I was just curious what, what was, if she was, if she was working with an attorney or what kind of, what was behind the agreement to do. There's, again, two documents, one pertaining to the pond and another pertaining to the water flow, right? There's two separate documents that she signed and agreed to. Just curious, what her take is on that now that it's kind of coming forth again.
Well, there's a few things that are relevant to that. Number one, she had acquired the property and there was existing ponding on the property. And it was represented to her to be a natural condition. She hadn't lived on the property or seen the amount of water that comes in from I'm not sure if it's 38 or 48 inch diameter pipe. But upon living on the property, she observed a different condition. In 2018, the water taking on is very dramatic. It was much, much greater to end of 2017 and 18 when she began having these problems. I'm on city council for the town of Ross. And one of the things that's very obvious to San Anselmo and Ross council members is that our flooding in the Ross Valley has been increased, and significantly so, by hardscaping uphill. And so I would not be surprised if hardscaping uphill is one of the reasons why we have a very changed condition. So I can't speak to everything that happened at that time, but I do know that the water taking onto this property was very, very different. And if the water, there is still, I think the staff called it a water feature, and that's the most appropriate way to describe it. There is a water feature on this property that takes water in. It's seasonal. It takes it in for the most part when the subdivision above is draining onto the site. But it was appropriate to contain it into a small area where it takes on. And she hired a engineer who specifically stated that this was the improvements that were done appropriately to handle the drainage and deal with the numerous sinkholes and 4 very mature trees which were falling in the street and around her property. So it wasn't like there was an option here. Things had to be done on site, and they were done. City only ever red tagged her for one item, which was Gelati's, repair and raising of the driveway, which was necessary also to repair damage.
Understood. Thank you.
Okay. So, Ms. Breckus, you stated that it should be up to the city to make a determination whether there's wetlands or not. But at the same time, you acknowledge that there's been flooding on the property, and that's the basis of litigation. Those things don't seem to mesh with me. Can you give me some clarity?
Well, your first point is it should be up to the city to determine, and that's not correct. That's not what I'm trying to say. So I'm sorry if I wasn't clear, because what I meant to say is it's on this burden. The burden is on, once you spend SB-9 application, the city has to deem it complete or deem it incomplete. So now what the city is saying right tonight is let's deem it incomplete because she has not submitted proof of, wetlands and habitat. And we want her to submit a professional opinion. And what we're saying is that burden has already been looked at by the AG and other counties, and they allow one to submit maps which show that that is not there. In addition, the AG, the state AG, has said when you have developed property with a single family home, that's not the same as wildlife habitat, that you already don't have wildlife habitat. So what I'm not saying it's the city's determination. I'm saying it's the city's burden to prove contrary. They don't get to just say, well, we don't know, or well, we think it's a conflict, or even as the city did today, try and point to Miss Locks, who is a layperson with no superior knowledge, 2000 letter before she consulted with engineers and experts, where she called it an area of habitat. And so the city's burden is to produce an expert if it thinks it can find one to support its position, not throw hurdle after hurdle after hurdle through SB-9 applications to deny the application. Your second point, I'm sorry, can you tell me what was inconsistent with that point to my other point?
Well, I think you've established that there's a lot of water that runs onto that property from uphill neighbors or wherever it's coming from. You've stated more than once that the property floods. And so it seems odd to me that now there's a question, or that the cities have the burden to determine it's a wetlands when you're acknowledging it gets wet and it's
Well, most of the town of Ross and San Anselmo flood. That doesn't make them wetlands. And her property floods from the unnatural diversion of city water, not from any natural flow of water onto her property. And so again, you get a lot of water on property, that doesn't make it wetland.
Okay, thank you. So I do have another question. And so SB-9, my understanding of the point of SB-9 for subdividing is to provide housing. Is that your understanding of it?
That's correct.
It's stated repeatedly that there is not only an artist studio that wouldn't be habitable, but that there's no intention or projection of any kind of construction on the site. And is that also accurate?
It is possible that Ms. Locke would make the artist studio habitable through an application to do so. She has not applied for one. Now, one of the reasons why it's not appropriate for this matter to be before a planning commission with all sorts of possibilities of, is this appropriate? Are there zoning violations? Should we, be red tagging it? Do we like the way the house is going to be? Could it be, are we going to really build? Is because it's ministerial. So it's not appropriate to inquire into. But the structure, her intent, if she, would be to keep the structure as it presently is.
Okay, I think I understand your position. Yeah.
I just wanted to offer a point of clarification that I think, just for the audience listening and also for staff, my presentation earlier of a hypothetical situation of what if somebody was building structures without permits on the property was not specific to this property. That was me asking the city attorney, what if something like that happened in the future, and how does SB-9 apply, and how does the city ordinance apply? And I apologize about my joke about asking if Miss Wizard was still there, but I thought the appellant's reaction was interesting and telling to my example. So just wanted to clarify.
Right. And my question was to get sort of to the bottom of, if SB-9 is being invoked, is it following at least in my mind, the intent of what the legislature wanted with it. And I get it that it's not before us right now, that we're looking at the permit, whether it's appropriate and should be, processed or not. So let's see, do we have any other questions? Because
by the way, are these questions for Ms. Breckus, or can we start questions to staff as well?
Well, we need to get to a public hearing.
Yeah, right.
And so then we'll come back and have another round robin. But I just want to make sure everybody's had a chance to at least talk to Ms. Breckus at this point. Okay, so I will make an announcement that I did visit the site. I had a conversation with Ms. Locke. I went by there on Friday and was told that I needed to come back Sunday and was denied access. And her attorneys acknowledged that. I nonetheless still did look over fences and still observed the property. I will I'm familiar with the property in that 20 years ago, I was on the commission when we talked about annexation. And I do remember the riparian area. I do remember the wetlands that were on that site at the time. It was difficult. I typically try to visit sites before we have these hearings. And that site was closer to a jungle than anything else, and it has changed dramatically. So with that, I will open up the public hearing. Do we have anybody that wants to talk to us?
So if you're wishing to address the commission at this point, please raise your hand and we'll acknowledge you to speak. I'm not seeing any three of the attendees raising their hand.
Okay, thank you. So back to the commission at this point, whether it's further questions or discussion or debate, maybe we got some more coming from the city attorney. Yes, sir.
Yes, again, Jeff Walter speaking.
Yeah.
I want to clarify what the commissioner earlier commented about the two unpermitted structures on the lot. I think Ms. Breckus, because she's not here, couldn't really hear all the exchange that was going on between me and the commission in that regard. I did not indicate or state that there were two unpermitted structures. It was a part of a hypothetical that was posed to me, and I was responding to that hypothetical, Ms. Breckus. I do want to address a couple of her comments about what the Attorney General has said. She actually put a quotation on the PowerPoint from the Attorney General allegedly declaring that land that is already developed, particularly with a single-family home, is presumed not to be habitat. Mm-hmm. There is a quote to that effect from the Attorney General in a letter that he sent in January to the town of Woodside. He did that because the town of Woodside, being clever, decided to declare the entire town as exempt from SB-9 because it had habitat for mountain lions. It was not a parcel-by-parcel analysis. It decided it didn't want SB-9 subdivisions in its town. So apparently it reviewed some maps, and not apparently dissimilar to the maps that Ms. Breckus has submitted to you, that indicated there were mountain lions in the region. And they just declared the entire town exempt from SB-9. That kind of sort of cavalier approach to the law is treated very seriously by the Attorney General, given the thrust of the legislature to adopt laws that are encouraging housing in the state of California. And in that context, he did say, I'm quoting, land that is already developed with, for example, a single-family home is not by definition habitat. There's no citation to case or statute. That's just the AG talking, which is interesting because within about 3 or 4 sentences later, he says, oh, in addition, any exemption under SB-9 requires examination of the attributes of the individual parcel. Well, they're completely inconsistent statements to have a presumption that then he admits, oh, well, you really have to look at each parcel individually. So this was an AG opinion that was reacting to an extreme action taken by a city attempting to exempt itself from the entirety of SB-9, which was not likely to succeed. The last comment I'd like to make is this. The city has a variety of ways of indicating that something has been done illegally. It's not confined to a particular action, such as revoking the 2020 permit. To be candid with you, the city is likely to initiate those proceedings in the next 3 to 5 days to revoke that permit. But we all probably are sanguine enough to know that that's not likely the last word on the subject. That will be appealed, and even if the council upholds the revocation, we've already been in litigation already. It's likely that that item will be the subject of litigation and will remain unresolved for some time. Is the city then handcuffed and unable to act on its own, in its own belief that that permit was illegally granted without full knowledge of the facts? Of course not. And I mentioned one way of doing that is when, if and when the commission and or council or staff approves this SB-9 lot split, assuming it can, in my view, it has the power to condition that approval on those illegal grading activities to be corrected. That too will generate another piece, probably, of litigation. But my only point is that the city has a variety of things it can do and can continue to do to insist that this activity in 2020 is illegal. And the fact that a permit was granted is not the be-all, end-all of the city's power to take those positions in a variety of administrative contexts. Thank you.
And just sort of knowing how attorneys are, Ms. Bacchus, did you want to respond as well to Mr. Walter's statements?
Thank you very much. I don't have anything further to add. I'll let my prior comments stand, and I wish you a good night.
Okay. Back to the commission.
I have some questions.
Chair Tiernan.
Yes.
Could I respond to Ms. Breckus's interpretation of some of my comments before you take it back to your discussion?
Of course, yeah, Ms. Kroll, yeah.
Okay, thank you. So I just wanted to state for the record that I disagree with Ms. Breckus's interpretation or restatement of my earlier advice to you. She indicated that I stated that the city's rejection of the application was erroneous and that staff's position on the rejection is changing, but neither of those are true. And just to reiterate, as I said before, it's my opinion the city was well within its authority to reject the application as incomplete because the applicant has thus far refused to provide evidence demonstrating compliance with the SB-9 application requirements. And this position is the same position that staff has already taken, which is on page 6 and 7 of your staff report. So I just wanted to make sure that it was clear to the commission that I don't think staff is changing its position. I concur with with staff's earlier rejection of the application as incomplete.
Okay, thank you. So again, back to the commission. Yeah,
I had a couple questions.
Yeah, Commissioner Kirby, yes.
So I'm just going back to again, because one of the things we're discussing is whether it's out of compliance with zoning. I keep jumping back to the two agreements that were, entered into the drainage management plan, whatever you're calling the agreement with the city for the natural drainage way, right? Am I correct? Those two things exist. And I couldn't read them with some of the focus on, I'm sorry, the scanning wasn't great. But I was trying to understand those and see if those were violated. By the way, hypothetically, if something like that was violated, why is that now a zoning issue rather than, hey, you violated private agreements that you had with the city that were part of a condition of approval to be annexed into the city?
So from staff's perspective, we're looking at those agreements as the outgrowth of the pre-zoning action that was done in 2000. So that pre-zoning follows a section in our zoning ordinance. I can't cite the section for you off the top of my head, but nonetheless, there is a section that talks about the procedures and criteria for pre-zoning. And in going through that procedure, the City Council adopted 2 conditions of approval, or actually more than 2 conditions of approval, one of which was the requirement for the drainage way maintenance agreement. So we view that drainage way maintenance agreement as an extension of the zoning ordinance because it grows out of the actual pre-zoning ordinance that was adopted for the property. So if you think about it in terms of a larger, say, master plan or precise development plan project, where the resolution or the ordinance establishes standards, those are in effect standards of the zoning ordinance. So therefore, if there's a violation of those standards, they're treated as a violation of the zoning ordinance.
Got it. So it's treated sort of like a development agreement, and again, it's a violation of something that is specific to the zoning, and part of that zoning was you need to keep this wetland pond waterway intact.
Correct. Part of the zoning action was to condition leaving the drainage way in its natural condition.
Okay.
To further Steve's point, it's actually attachment 7 to your packet.
Okay.
This is the ordinance 1431 that was adopted by the council in 2000 to pre-zone the property. If you take a look at condition number 1 under section 3, the owner shall submit a drainage management plan. Condition 3, the owner shall enter into an agreement. So it stems from the zoning action itself.
I see.
And so a violation of the agreement is a violation of the ordinance.
Got it. Okay. And then again, just going back to what Ms. Brecka said, was there no notice of zoning violation here? Is that in fact true?
So our code enforcement division identified a building code violation, which is a general grading violation. Thereafter, when litigation began to ensue around the property, the planning division was contacted and asked to look at what had happened at the property. And there had not been any contact prior to that. And as staff looked at this particular issue, we went back to the old project record on the property. And that's where we identified the drainage maintenance agreement and the stream management protection plan. And we said, we have a problem here. These agreements are binding on this property. They precluded filling or changing that waterway into a change condition. And that the procedures that go with amending an agreement or amending a zoning ordinance had not been done. So there, in fact, that's a zoning violation. So through the process of working on the SB-9 application, staff included a section in the first completeness letter citing chapter and verse of the sections that were in violation, that we believe to have been violated by that grading.
And finally, was there any agency involvement when these were put together, when you were looking at drainage management plan, this waterway? I mean, was it ever delineated? I'm assuming as part of the plan there was some work done to identify exactly where the waterways were and what she can and can't do.
Yeah, unfortunately, none of us were direct. I was here with the city, but I was not directly working on this particular issue. But the file records don't indicate any sort of jurisdictional wetland delineation or biological report. I believe the waterway was simply treated as a natural water course that went through the property and was accepted as such without other evidence.
Okay. And then finally, if you were in a situation, again, maybe let's just say this is hypothetical, where you were in a situation where there was water, flooding your property, how would a citizen in Novato typically deal with that? Especially if there's a drainage management program here. Is that something you'd reach out to the city about? Was there records of her reaching out and saying, hey, we have a problem here, help me?
So typically from staff's perspective, we would expect a resident to contact our public works department to talk about a drainage issue, in particular where it is, there's concern that it may be coming from a city drainage system. That's particularly important to contact the city because that drainage system serves a larger area typically. So you don't want people making adjustments without having appropriate studies and engineering review. To my knowledge, there are no prior complaints about the performance of the drainage way through the property.
Excellent. Those are all my questions. Thank you.
Great. Yeah.
Okay.
Mr. Havel?
We are finished with public,
I'll
open
close the public hearing.
Just wanted to make sure before
Yeah.
I dive in here. Okay. So to start, this notion that the city and that there's some sort of a shady conspiracy going on. The city is us. We are the city. And I reject the notion that there's some bigger agenda going on here. I'm a bit disappointed that, I understand Ms. Locke might be just a layperson, but she's a layperson that was aware of this previous agreement with the city. She was there. She signed the agreement. And while, yes, she may have suffered some damage from drainage, it sounds like a substantial amount of damage from some drainage issues or other land-related issues. That's not to take that out on this, that issue doesn't absolve her of the agreement that she reached with the city back in 2000. So in those materials, what was provided with the staff report, the agreement, the plans that they were shown tonight as well, the plans were prepared by LDSI, and I believe it's Michael Tarnoff, they've been around for a long time. They identify stream protection zones and riparian habitat and vegetation on the plans. So when we talk about the burden is on, the community development agency or somebody in the city to show that there's some indication of habitat there you go. It's right there in the drawings. Like, I don't understand what the debate is about. I did take a look at Marin Maps. It is a website prepared by the Marin County Community Development Agency. It provides information that is general in nature, but it does provide information that's also site-specific. That information is something that helps guide, I think, staff, members of the public, when there is an issue. So, for instance, if you're developing a property, if you're looking at doing something on a property and you go to Marin Maps, or there's some other source of information that says there could be a condition here, that's when somebody advising an applicant, such as Ms. Breckus or Gelati Construction or some other reputable firm, they should have stopped and said, hey, wait a second. Back in 2000, you signed this agreement and it says riparian habitat right there. So we need to get a biologist on board to clarify whether or not this is some sort of habitat that provides, something bigger. If what is it? Let's get down to the base of it. The geotech report that was provided with the application materials, if I understood it correctly, was from 2000 for the residents. Is that correct, staff?
Yes, that sounds correct.
So again, geotechnical, I recognize that it was a geotechnical report from 2000 for a specific project at that time. That's not applicable or specific to the proposed lot split here. So again, I'm a little bit concerned about that as well. I realize that on a geological time frame, a geotechnical report can, extend and still be valid, but that was for a specific project at a specific time and is not specific to this lot split application. I'm a little bit concerned that maybe Ms. Locke willingly deceived staff. Maybe she knew this agreement existed and she didn't tell staff about it. She didn't come in, she wasn't forthright about it. I don't know, I can't say. I've just got a concern about it. It doesn't help us all work together if we're not providing that information. It sounds like she didn't tell Department of Public Works staff. Grading permits, typically, my understanding is that a grading permit is I don't want to call it routine, but it's engineering based. So you're dealing with numbers, you're dealing with as much data as possible, and the focus is on, is this a feasible project? Is the sheet flow or whatever drainage that's occurring on the property, is it going to meet city codes, as well as, is it going to cause harm to other properties or other drainage systems in the area? And that's kind of the focus of a grading permit. A grading permit doesn't look back at, and correct me staff if I'm wrong on this, the grading permit doesn't look back on the history of what land use decisions or agreements were made before. It's just focused on that specific sort of activity that's being proposed at the time. So I don't think the fact that the city issued a grading permit, again, absolves the applicant of, previously understood or previously known conditions on the property. I will note that I did do a site visit on Sunday. I did not attempt to go into the property. I didn't knock on the door. So I drove by, kind of looked through the gate and carried on. Mm-hmm. And I also received letters from Ms. Breckus, the May 23rd letter. And then I also saw from staff the May 22nd document from, looks like North Studio. Finally, I appreciate outside counsel's sort of weighing in on this topic. I think I understand where she's going with it in that, and again, staff, I actually do support staff's position. I think that the city does need to have the discretionary authority, the muscle to say, yeah, if you've done something without permits on your property, that doesn't mean, SB-9 doesn't get you out of that particular jam. You still have to comply with the rules of the game, how we develop property. But I understand outside counsel's push is more for, I think, limiting the focus to something that's more clear and more defensible in terms of moving forward. And it's probably in the anticipation that there's going to be future litigation on this. So I think it was outside counsel is recommending striking, was it items 1 and 2 from the resolution, from the proposed resolution? I just want to make sure I'm clear on that part.
That's correct.
Okay.
1 and 2 under section 4.
1 and 2 under section 4. And those are the
findings.
Yeah. The findings. So that's the planning division did not deny the application as asserted by the applicant, but rejected the application consistent with the provisions of Novato zoning. So that question of the Novato zoning code, I think, is what outside counsel is concerned about. And then number 2, planning division decision to reject the application is reasonable and appropriate in light of the unresolved zoning violation. So again, it kind of goes back to that code section 19.40.070.b.2. So again, I understand where outside counsel is going with that, but I also support staff's statement of that. But I could support a resolution where we strike 1 and 2, just to kind of focus the resolution so that it's more defensible. Thank you.
Okay. Let's just ponder that for a second. So what you just suggested is amending the resolution that's before us, striking out of section 4, 2 of the findings? Is that what you're suggesting?
Consistent with the recommendation from outside counsel, yes.
So I'm sorry, aren't there really 2 issues that we're being asked to consider? The first being whether we're meeting the threshold or not, right? And I think we, as a group, should vote on that, whether or not they should accept the SB-9 application. And then the second one, of course, was staff correct in deeming it incomplete? And those are the 2 actions we need to take or weigh in on, correct?
That's correct.
Okay. Maybe we should break it up into those 2, because there's been so much thrown at us.
Okay, because the resolution combines those. So you're suggesting that should be a split item, that there should be two separate motions?
I think that would probably be okay, but that's staff and legal.
So the suggestion is just to adopt the resolution with just finding 3.
Finding 3 being?
Page is that on?
That is the finding addressing deeming the application incomplete.
The planning division decision to deem the application incomplete is consistent with the procedures codified in the Novato zoning code section 19.40.070A. Further, the planning division's decision is valid and justified on the basis the applicant did not submit adequate information, determine whether the property meets the criteria of Government Code section 65913.4 at all, and section 65913.4, etc., and is thus eligible for subdividing pursuant to California Government Code section 6641.7.
Okay, I sort of lost.
So that's what it says, but basically it's just sticking to
an application being
the
inconsistent.
completeness question.
Or incomplete. Okay, it seems that we then would skip over, or I'm assuming it's a separate vote, whether those previous code violations can be enforced or not.
Maybe we agree, before we decide on one of these, maybe we talk about the 2 issues here, because I really think those are going to determine which one we put forward. Am I wrong, off base, or
Okay.
And so I think, because I would guess just from Commissioner Havel's comments that his opinions on at least the first thing, meeting the threshold, might differ from my own. And so I'd be curious what the rest of the commission would think on at least my personal opinion is that it is ministerial, and I agreed with the outside counsel on her point that she was making on that. I'm curious if anyone else agreed with that, but I think if more of us agree with that, then I think we're going to change how we do this, right?
Well, but I think the distinction was that what staff was reviewing is completeness. And so it's not denying that it's an SB-9 application. It's just rendering it incomplete until such a time as more information is provided.
Okay.
Oh,
But I think there's, my concern is that if we say the reason it would be incomplete would be around the habitat, protective habitat issue, and I'm concerned that there's not a clear way to prove that. We talked about whose burden is that? Is it the applicant or is it the city? But also, what is the burden? Does the city accept a map? Is it someone's photos? Is it an environmental expert? What is the burden to prove, to make it complete?
Do you have a kind of a suggestion in mind? Because this is ultimately a recommendation to the city council so that they can wrestle with this too. But if you have something you'd like to...
I guess I'm wondering if there's anything the city has used in the past. Is a map sufficient for something like that? What would be a sufficient way to prove that this is or is not wetland?
Hypothetically, with let's just say a standard development application, subdivision map, not subject to SB-9, we would take in an application, and then one of the first steps is determining if it's exempt from environmental review or if the city needs to complete an initial study, possibly a mitigating negative declaration or environmental impact report. And part of what we're looking at would be potential constraints on the site associated with wetlands and or habitat for special status species or the presence of those species on the site. And if it was determined that there was the potential for those and we were not able to exempt a project from environmental review, either the applicant would submit a special study by an individual, a qualified professional that they hired to submit to the city for review, or the city were hiring a CEQA consultant to write the environmental document. That CEQA consultant would complete a biological opinion, go out, assess the site to determine if wetlands are present, potentially submit those to the U.S. Army Corps of Engineers for wetland delineation. So that would be a standard procedure.
But this one's more difficult because the wetlands maybe were there previously, but not currently because of the work that was done. And then I was just going to add the opinion that also I did a drive-by and kind of could see through the fence a little bit, and the pipe that creates the stream is huge and very apparent on the property and doesn't really look sort of like a natural habitat stream, though I obviously didn't see the property in its original form.
Chair Tierney, if I may add to Brett's answer on the wetland mapping issue. So there are a lot of data sources available out from various public resource agencies about wetlands, waterways, and such, but they're not comprehensive. They don't capture everything. And so often when we have a site, we look at indicators for conditions of wetlands. It doesn't take a biologist to identify indicators. And indicators would be riparian habitat, oaks, various understory growth, the presence of water. So that's enough to raise a suspicion that perhaps we need a qualified professional to come in and go through the process of looking at whether or not it is in fact a jurisdictional wetland or it is a waterway. So maps are not always going to be helpful, taken from the public domain. And so the city needs to have the ability to either have an applicant, have their own professional go out and do it, and when I say do it, prepare a report on the feature, or access and funds for the city to have their own professional do that. And one of the things to keep in mind about SB-9, SB-9 is crafted around these provisions that are in fact listed in SB-35. And these are qualifying criteria to ensure that a project is not in fact going to cause an environmental impact. And that's the legislature's way of setting up criteria so they can deem these applications as ministerial. So there is a burden here to actually prove up that a project is in fact not going to have these conditions that could lead to an environmental impact. So I am very certain the legislature was not intent on allowing unfettered residential development at the expense of wetlands and waterways. So I think these are issues to be cautious on and not buy into what we hear frequently as staff, which is, well, the legislature says we get housing and we get housing. It's not so. It's a little bit of tough love in there to prove up that your site is eligible and that you've met the requirements to qualify for whatever housing law relates to the particular issue. So I just wanted to add that in there. Thank you.
Okay. And I guess with the notion of wetlands being one of those criteria that is a qualifier for SB-9, in this particular instance, because there's evidence on the record that there was something wet on that site at one time, an agreement was entered into to that effect, and there's been no additional documentation provided by the applicant related to this current subdivision proposal. I would argue that until that's provided, that it's not an SB-9 application, or it doesn't, and it's legitimately been declared incomplete.
And I will point out that attachment 6 in our packet is done by an environmental, professional. Maybe it was 20 years ago, but it seems to me that this is a totally valid document that establishes where the wetlands or the drainage areas are on the property. And so back to your point, what kind of authority do you want to see? I think we've been presented with some. Unfortunately, I think the genie's sort of out of the bottle, because seeing it now, you wouldn't recognize it as the same property 20 years ago.
And I don't think we're trying to say there is or isn't wetlands. We're not qualified to do that, nor is potentially what we're looking at stating it was wetlands or not wetlands. But it was an agreement, and what I'm understanding is because that agreement was, maybe I can say violated, we are now out of compliance with the zoning. And that was one of the reasons that this was incomplete.
All right.
And of course, because there was wetland, or we don't want to say there's wetlands, but because there was some type of features there, like a pond, there's obviously a need for additional studies, and that's what the city's asked for. And then if those studies were done, then I'm thinking it would be closer to a complete application, if I'm not mistaken.
Okay. Well, my concern, I'm comfortable voting the resolution as it currently stands with both elements. The idea that previously the improvements or the preservation was not protected, and there were agreements to that effect, and that is a violation of the zoning code, as well as needing further documentation. This wetland aspect still needs to be addressed. There are obviously areas there that I believe need to be corrected in a big way from the way it was. This property was annexed, so it was to get on the sewer. There was water that was not appropriate getting into the wetlands or into the drainage area, and my understanding is that was the idea of the original project, was to clean up that area, and at the same time they agreed that they were going to leave the pond alone, keep it as riparian. So I'm skeptical about this whole SB-9 stuff and all, but that nonetheless, that's not what before us. What's before us is whether we're going to accept the appeal that would then move their project forward, or reject that appeal that says that their proposal currently is not accurate, not complete. So I don't know if I garbled that too badly, but that's sort of what's before us.
Do you want to, Chairman, if I could just add a couple of things just based on my observation to try to, just things I haven't heard others say yet. I think this project by this owner has been managed like an island. And when I went out to the site, and I didn't get in, I looked in the gate, but what caught my eye is this is at the base of some hills. Mm-hmm. And the fact that there was a pond, and I believe it was a stormwater retention pond, well, that's an actual working element on any site. It's very important. It's a staging area for stormwater so that it doesn't put too much water too fast downstream through basic gravity logic, et cetera. So when I look at this proposal overall, I mean, to cut to the chase, I agree with everything the chairman just said, but it strikes me that there's some language being stretched or manipulated here. For example, denial versus rejection. I don't know, it's my prerogative to, it's rejection is a rejection. If it's is it a wetland or not? Well, on this site, it's a site that floods and there's slopes above it and there's been a pond. So yes, it's prone to retaining water. And when it was last apparently engineered by a qualified engineering firm and the maintenance agreement was to maintain that was at the stormwater retention pond kind of configuration, something like what we saw. So I think what's being proposed is pretty vague, but there's a couple things I'd point out. If we split this lot, the applicant's lawyer, as I understood it, said just the little shed that's being used as an art studio will stay on that new split portion. There's new construction proposed. Well, that's only part of the truth. You wouldn't do this split unless there was some intention, as I understand it, of building another dwelling unit on the site.
That would be speculative on our part.
That would be speculative, but my point being, again, by the applicant's admission, they think, and this is speculation, that a contributing factor where there may have been a trend of more water coming onto the site over the years rather than less is more ground being covered with permeable pavement or you name it. Well, another dwelling or more development on this site will aggravate that further. So I don't think we have any information that is a solution proposed based on sound engineering and other, biological analysis that would give staff cause to come to us and say, we think these guys have done their homework, they've cooperated, they're going to make this site, they're going to mitigate any potential impacts. So I just don't see a basis where we frankly could support this.
Okay. Any other discussion, debate?
I have one last comment. Yeah. Just thinking about, obviously they didn't pull the correct permits to do the work back in 2020. However, just thinking that there was damage to their property. If it's true that there were sinkholes, they had to do something about that. And if there was damage to their driveway and they couldn't get in and out, they had to do something about that. And they should have pulled the proper permits. But I'm just thinking, even if they had all the proper permits, that probably would have affected the wetland aspect of that property. And so I'm not sure that it's sort of fair to say that they destroyed the wetlands by not pulling the permits. It was maybe work that had to be done.
For the record, people impact wetlands very often. You just need to go through the proper channels to do it, right? If there's a reason to impact a wetland, you go get a permit from the Army Corps of Engineers after it's been deemed an actual wetland, and you provide mitigation, or in this case, maybe if it's even retroactive, you might get charged a penalty fee. I've seen it happen. I'm a developer, right? It happens out there. And again, I think what we're saying is there's avenues to go about this, and perhaps they didn't take the right path on this.
Yeah.
Mm-hmm. Okay.
Well, I guess the argument of the neighborhood above discharging water and creating this situation, and this neighborhood has been there since at least 1971, so it's not like there was recently new construction that suddenly increased water flows through the storm drain system.
Right, but that's a whole nother.
It is a whole other thing, but yeah, I mean, it's again the issue of this water retention or water conveyance through the property.
Ultimately,
it's not like there was some sudden change in conditions that
right.
What was causing the sinkholes and things like that generated this need to have immediate work done. Who knows?
Right.
So Peter, do you want to suggest a motion or?
Well, I would move the resolution as presented by staff, but I had heard a suggestion that perhaps it should be bifurcated, that we should split some items. Now I got to unlock the thing.
Did council want to weigh in a little bit more on this? I know you were trying to explain something to us and sat down. Just want to figure out the best way to do it.
If you believe that SB-9 is a ministerial process and preempts the city's own section in its zoning code that says that if there are illegal conditions on the property, the application is to be rejected. If you believe that the SB-9 preempts that section of the city's own zoning code, then you would adopt this resolution without findings 1 and 2.
So in other words, if that's my belief, which it happens to be, I'll present that, but not everyone could agree with me. But I do personally, I am also going to vote that it is an incomplete application because of the violations of the zoning. So
Okay.
I'm kind of bifurcating something.
Could you elaborate on that a little bit more? I'm wrestling with that in my, I kind of don't. So if we believe SB says 9 is ministerial, then we would adopt the appeal so that it would continue forward.
No, the resolution supports staff's determination that the application is incomplete.
Right.
And this application needs to go back to the applicant, and the applicant needs to make it complete. And the way the staff is suggesting that be done is with an expert's report on habitat and wetlands.
Right, okay. But the idea that SB-9 allows those defects to be bypassed to move to a lot split would be rejected by taking this action to deny the appeal.
If you strike findings 1 and 2, then you're of the view that existing zoning code violations do not preclude the processing of an SB-9 urban lot split. Now,
Would allow for. Okay.
would allow for
So
the,
you got that
it
sort of
would
double
allow for
negative
the
there that
application.
got me
That's
going.
not an impediment to proceeding further with this application, but they haven't submitted a complete application for lack of information about habitat and wetlands. That means it still has to go back. It still has to go back, even though you find that the city's own code provision would not apply here. That's not a separate basis for rejecting the continuation of this application. And that's the advice of your independent counsel. On the other hand, legal advice is just that. You don't have to follow it.
Right. Okay, so
Again,
again.
so my pitch was I believe the outside counsel, and that I do believe it's ministerial and you can process it, but I also believe that the application's incomplete and it needs additional work done on the wetlands, habitat, whatever it will be, with a qualified biologist. That's what I would like to motion.
Okay.
I'll second it.
Okay, so on the question.
So I'm saying,
Then that ignores the previous code violations that are.
no, I'm not weighing in on the
No.
lawsuit or anything like that.
No, what it's doing is acknowledging that SB-9 is ministerial. There's this other bunch of code violations that have been going on. But what 3 gets to is there hasn't been a complete application that meets the criteria to qualify for SB-9 yet.
Right. Well, let me
That's what the additional information is needed.
But stop there. So, but if part of the code violation is the previous work done outside of the plans they agreed to in 2000, doesn't that kind of like cancel out?
It doesn't
There's a separate
absolve those
agreement.
issues. It's just for this approval, those aren't taken into consideration.
Impacts to wetlands is a basis for
Yeah.
one of the criteria for qualifying for SB-9 ministerial approval of a project. It cannot be determined at this time that there is or are not any wetlands on the property because, among other things, there has not been performance on an agreement that was signed to come up with a plan, and evidence in the record suggests that there was something there before that has since been filled in. And so until that question is resolved, they can still apply for an SB-9 grant or SB-9 approval, but they need to provide the information that enables them to qualify for it, and they haven't done so yet.
And the zoning code violation would be taken care of separately.
And then the code violation part can be pursued separately, but they still need to provide information.
Okay, so I was going to what if, but I think I'll just keep it to myself because that what if might really spin us somewhere.
With my motion, if you don't agree with it, you could also, we could present it slightly differently.
Well,
Commissioner Derby, can I ask a clarifying question? Sorry, Chair.
absolutely. Sure,
Okay.
sure, sure.
So you're proposing to adopt the resolution as put forward by staff?
No, as forwarded by the outside counsel. That
So
it's
striking
ministerial.
1 and 2.
Yes, that's what I'm proposing, but
Right.
that's my opinion. I'm not suggesting
Right.
everyone should follow it.
Okay. All right, well, that is the motion on the floor. Is anybody?
You should
did
ask
you
your-
second it?
Yes, I did.
Okay.
I mean, if you have a question,
So on that
throw it
question.
out there,
Well,
even if it throws us into a tailspin.
okay, so let's just assume that we make that as a requirement. You need to do a study and come back. And under the current conditions, and we've witnessed the property, they're gonna say, that's not a wetland. I mean, all the repairing's been ripped out. It's now, it may as well be a bocce ball court. I mean, there's stone walls and there's benches and so that person comes back with a study and says, it ain't wetlands. SB-9, I want that lot split. And at that point, I think then you get to bypass all those code violations and all the work that was done that was inappropriate, that wasn't permitted, and the wetlands that we lose in. And I think that, frankly, that's one of the reasons water's gonna fly through that site, because there's nothing to slow it down. There used to be, trees and shrubs and stuff to slow it down.
Yeah.
So that's, and I kind of hate tossing that out there, because that's,
But
but
again,
that
there's
really
lots
gnaws at me, the idea that we could somehow be leaving a back door that I
Well,
don't.
it still doesn't resolve.
It doesn't absolve the
Yeah, I mean,
violations.
there's, you can submit another report, but there's still evidence in the record that there was something there before that has been removed. And then that can be pursued as a whole separate action to have them corrected.
Okay, it's just, that's why I like the resolution together the way it's written, but fine, there's actually a motion on the floor with a second, but let's hear from council.
Thank you, Mr. Chairman.
Yeah.
The issues you've raised is that bridge that we don't have to cross yet. Let's see what the expert that the developer, Mrs. Locke, has to retain comes back with. Staff will then investigate that. We will investigate what the conditions were before the 2020 illegal grading, in the city's opinion, occurred. And then we'll do some further research to see whether SB-9 and other planning laws allow us to rely on maybe evidence that in 2000 there was habitat, there were protected species. If we have evidence that shows that, and it's clear from the record, then we can decide whether or not we can reject the application because the applicant intentionally removed features that would otherwise preclude this property from being eligible for SB-9 approval. There may be laws, and I would think there might be, that would support the city at that time, the planning staff taking the position. You intentionally removed criteria, features that now allow you to apply for SB-9 treatment. And we have concluded that that is an untoward, unsupportable action that we can use then to preclude SB-9 approval, and maybe even allowing for the further processing of the application. But as I said, that is something that we look to in the future. We're not quite there yet. Let's find out what they can come up with. We will then compare it with the evidence that we can marshal and make some intelligent decisions based on the facts at that time.
Okay, so at any rate, there's a motion on the floor to approve or to recommend for approval to the city council the resolution short of
1 and 2.
section 4 findings 1 and 2.
Correct.
Is that
That's
accurate?
correct, yes.
Okay. Any further discussion on that item? Okay, then I'll take a roll call vote on that issue. So Commissioner Derby?
Aye.
Commissioner Cronkite?
Aye.
Commissioner Heath?
Aye.
Commissioner Havell?
Aye.
Commissioner Dawson?
Aye.
And Tiernan will vote aye as well. I'd like to put forward, though, an alternative motion. I don't know if it conflicts that we accept the motion as fully as written, including 1 and 2. And with that,
I don't think we can do that.
I don't think, yeah.
I think you've already entertained a motion and taken a vote.
well, right, of the resolution with those 2 elements out of it.
But if you want to rescind you can say no.
Well, no, I do support the idea that the application's incomplete. It's just, I also believe the other elements that the code violations from the last 20 years need to be rectified.
And I think that just kind of got left.
I don't think we were voting on that, though.
Well-
That's a whole separate issue that the city is dealing with. This was really just about SB-9. The reason I was kind of passionate about it is because I do believe it's a ministerial process.
Yeah.
And it qualified to be an SB-9 application, but it was deemed incomplete because certain things weren't met with the zoning and relating to the studies that have been done.
I know.
I think I have that right.
It's just, I've also seen how litigation works, and when somebody says, oh yeah, but they intentionally left out, this idea that, it's not consistent with provisions and you can't enforce them now, neener. I mean, I've seen that play out in court many ways. But we've taken action. I guess we'll see where that goes. So we've recommended the city council, and they'll obviously have a lot to weigh in this issue. Any other comments on this?
I was just going to say, Chair Keenan, that I think I can second your feelings on that. That, yeah, I have concerns about, I do think that the city does have the authority to go after and regulate that, from an enforcement standpoint. So I'd like to think it's not off the table, and I think that our intent here hopefully is somewhat clear.
Well, right.
That we're not
and I think
absolving anybody of
city attorney just
any violations.
verified that indeed it does not preclude other enforcement actions down the road. It's just that's my concern, that as long as we're on the public record and taking a hearing and putting stuff in writing, that it be as, cohesive as possible. But with that, we'll move on to the next item unless there's any further action anyone wants to take. Okay, so let's move on.
Thank the applicant and everyone else. Assuming they're still here.
Assuming folks are still on, and we're okay to move forward, do we need a break? We're moving forward.
Let's do it.
So before us is the general plan consistency report on capital improvement programs fiscal year 2022-23, proposed new projects. It looks like staff, Mr. Blunt is here.
Good evening, Commissioners. Give me just a second to get logged into my laptop here, and then we'll get a presentation up on the screen and we'll get started.
And while staff is preparing, I'd just like to say a quick hello to Jay Strauss if he's out in the audience, and thinking of you fondly, Jay. Commissioner Strauss.
His favorite item.
This was one of his favorite subjects, you're right.
Always. All right, I'm ready to go. Thank you again, Chris Blank. I'm the Public Works Director for the City of Novato, and we are here for our annual capital improvement program update. We do this update every year as a part of the budget process, and a part of that process includes general plan consistency findings to be made by the Planning Commission, which is why we're here. So tonight's request specifically is that you adopt a resolution that would report to the City Council that the proposed new capital improvement program projects for the upcoming fiscal year are consistent with the Novato General Plan. And I'll give a highlight of the CIP update process. It's a 5-year capital planning tool. So basically, we try to capture as many of the city's infrastructure needs as possible. And then we program the different types of special revenues that we have that come into that program over the next 5 years to try to take care of the need that we have. We update projects and funding annually through the budget process. I already mentioned that. And the program identifies and prioritizes projects based on regulatory mandates, general plan and strategic plan initiatives, input that we receive from the community as well as the City Council, documents that we have on file, assessment plans for condition of facilities, and then the restrictions that we have in our capital revenues. So I mentioned that we can't use gas tax to go put a new roof on a city building someplace, right? So we have to match the funding that comes in with the need that we have. High-level summary of the program for next year. We're proposing there would be 52 total projects in the CIP. That would include 6 new projects. And I'll mention there was a typo. I believe in the very first paragraph of the staff report, it said 7 projects. We're only proposing 6 for next year. Those projects are made up largely of what we call our transportation, drainage, and utilities category projects. There's, you can see, about 75% of the program are going to be streets, sidewalks, storm drains, really our critical infrastructure. We've got 9 projects that are parks, rec, and community facilities projects. Those are, playground upgrades, things like that at our parks facilities. The municipal facilities tend to be building related, so that would be roofing and siding on buildings, HVAC, things like that. And then we have a category, what we call technology and organizational improvements, and that's for the acquisition of large software for the city, because those are large capital purchases. So they live here as opposed to in the operating budget. In addition to the new projects, we're proposing new funding for 18 ongoing projects for a total of about $2.5 million. And the 6 new proposed projects is about $2 million of new funding that we're proposing there. So I mentioned a little bit before the Planning Commission's action. Government Code Section 65401 and 65402 require municipalities to submit their annual list of projects as well as new structures to the local planning agency, which in this case is the Planning Commission, to make findings to the City Council in terms of consistency with general plan. So that's why we're here. The new projects for next year, you can see are up here. Our first one is the annual pavement rehabilitation project. Every year we try to invest a significant amount of our gas taxes back into the city's street network. We go through a process every year to select the street segments to be repaved. We're not quite there yet with this project, but we are putting the funding together based on the revenue estimates that we have coming in. So you see about $1.6 million, $1.7 million going into that project. We have a SCADA system, which is a systems control and data analysis system. It's basically a computer that controls the pumps at the Hamilton pump stations. That system is at the end of its useful service life, and we'll need to replace it in the very near future. So we've made a project to do that. We have wooden streetlight poles all over the city, and they're heavily concentrated in several neighborhoods like Bahia and Pacheco Valley. We're seeing many of those wooden streetlight poles are at the end of their service life as well. Woodpeckers love them. We just lost one. Can't remember the street, but woodpeckers took it down. They rot out. They've been in for a while, and they need to be replaced. We have something like, I want to say 1,600 of them total, and it looks like right now in today's dollars, it's about $8,000 a piece to replace them. So there's a huge capital need here, about $12 million. Obviously, they're not all bad. We don't need to do that all today, but we are programming funding, as you can see in the next few years, to start to address that need, kind of year over year, based on the highest priorities first. Next project is the Linwood Slough Storm Drain Project. This came out of the City Council's adoption of the city's storm drain master plan. This is a project that identified upgrades that needed to be made to that existing system, and we wanted to get it parked here as a placeholder. This will allow us to apply for grants and look for other funding opportunities to try to make those improvements in the future. Out of the strategic plan that was adopted came the next project to evaluate the Simmons House to relocate the History Museum. So we are programming funding in next year to do that assessment and determine what we would need to do to that structure in order to relocate the museum there. There is no capital funding programmed here. This is for preliminary engineering feasibility study, basically. And then the last project we're calling accessibility upgrades to San Marin Drive at San Andreas Drive. If you're familiar with that intersection, it's enormous. There are free right turn lanes on every leg, and it can be uncomfortable for pedestrians to cross there because it's just very, very wide. In addition, there are no curb ramps at that intersection. When we resurfaced San Marin Drive last year, when we resurface a street, we're required to upgrade all of the pedestrian facilities to be accessible. And we made the decision to pull this intersection out of that paving project rather than paving through there and replacing 16 curb ramps with this really large and, in my opinion, probably not necessary to serve traffic operations intersection. And we said, rather than spending all the money to upgrade this, we think we can do better. We think we can put in bulb outs. We think we can narrow some lanes and make this more pedestrian friendly and better serve the neighborhood. So we skipped it in the paving project, and we're proposing to come back here in a couple of years with an actual project to reconfigure that intersection. So Those are the projects. I'm not going to get into all of the consistency findings. We spelled them out in the staff report pretty extensively, so I'm happy to answer any questions on those. I also have a slide here. I know the commissioners often have questions about other projects. This is hard to read, but it's kind of more to jog my memory. If you all have questions about other things that are going on in the city, I can come back to this. I won't read those off to you, but these are the other projects that we're proposing to add new funding to. And lastly, I'll close with some work that we've gotten done recently. Our staff have been working really hard and continue to work all the way through the pandemic to deliver quality projects for the city. Almost all of them on time and under budget. I'm really proud of our engineering staff. I mentioned the San Marin Drive pavement resurfacing. We also replaced $1.5 million sewer pump at our mobile home park, and we'll be starting on the next phase of that project coming up here probably in the next month or two. Replaced the Pioneer Park retaining wall along Simmons Lane. That project also actually came in so under budget we were able to add additional wall to that project as a change order elsewhere in the city. Storm drain master plan, we completed it. We've got a backup generator installed at the admin office, repainted and waterproofed the city administrative building, and we've got new EV chargers, I think, in all of our city facilities now. So in addition to a whole lot of other work, staff have been doing a great job, so we're very appreciative of that.
Okay.
And with that,
Thank
I'm
you.
happy to answer any questions. Thank you.
Good. I have a couple. So the replacement of streetlight poles, are those sometimes utility poles? Will that coordinate with other entities, cable companies or electrical, or are all of ours standalone?
What we're looking at specifically in replacing here are standalone poles. So if you drive down Topaz Drive in Bahia, right, you'll see there's probably, I want to say it's maybe a 15-foot tall wooden post that has a lamp head on the top of it.
4x4s.
Yeah, so we experience a lot of rot in those poles in Bahia. The new wooden poles that we can't replace them with something new. They're not commercially available. And so we're looking to put in a standard metal pole to replace those. The utility poles that happen to have mast arms on them are owned typically by PG&E, and it's responsibility of PG&E to replace those poles as necessary.
I see. Okay, so that's a different animal. And then as far as the storm drainage project, I'd imagine that also needs to coordinate with the county flood control?
Definitely, we would bring in Flood Control District 1 into that project.
Scottsdale?
Yes, yeah.
Okay.
Yeah, that's all connected to that system.
Yeah. Keep that clean, yes. Okay, I'll open up the thank you. I'll open up the public hearing and see if we have any comments from the public on this item. Is Jay Strauss?
We have no attendees at this moment.
Nobody talking to us.
No Jay Strauss.
With that, I'll close the public hearing. Any other questions, discussion, debate? Floor is open for a motion. Okay, sorry. We're gonna go.
We make a motion, or is this just, I think he just presents it, right?
Yeah, I'll move the resolution recommending findings of consistency with the general plan for the EIP.
Second.
Excellent. Okay, and now we'll take a roll call vote. Okay, Commissioner Dawson?
Aye.
Commissioner Habit?
Aye.
Commissioner Heath?
Aye.
Commissioner Crockett?
Aye.
Commissioner Derby?
Aye.
And Commissioner Tiernan votes aye as well. Thank you so much.
Thank you very much.
Okay, so we've taken care of our agenda. Committee and liaison reports is what left. I think this pretty much puts you on the spot, huh, Steve?
That's correct. So we're looking at a pretty busy summer, actually, with housing element-related work, as you all know from the frequent quorum checks. So looking to our next meeting, Monday, June 13th, we do not have a quorum for that meeting. It seems the commission wants to take a vacation at that point, or commissioners do. So we encourage that. So that meeting will be canceled for lack of a quorum. However, on the return back on June 27th, we're going to have we're tentatively scheduled for a housing element study session. And that's slated to include some feedback or providing feedback to the commission about focus groups that have been interviewed, as well as a community survey and some other input. So Community Development Director Parker will be leading that up with the city's consultant, Lisa Wise Consulting. So look for that on the 27th. And then heading deeper into the schedule in the summer here, we have two more housing, a workshop and a study session for the meetings in July.
Okay.
And we'll likely have some other items come up that will be added to those agendas, but we're generally trying to keep those agendas light since they do involve housing element issues.
Okay, okay. And I understand, I think on the 27th there's an appeal as well? Will we have?
It's possible we'll have an appeal ready at that point. That's an appeal of a zoning administrator interpretation of the code. So that's might be new territory for the commission, since I can't recall having one of those, but nevertheless, it will be showing up.
True, that's true. Okay, any questions? And I do know you sent out a notice, which was great, for a seminar or a program for planning commissioners.
I think it was, I'm trying to remember the organization. It was like the Institute for Local Government, I think was the name of it. So certainly encouraged to go. There was no charge for it.
Yeah.
And I believe it was all online, if I'm not mistaken.
Right. And do you recall when it kicks in?
Not off the top of my head.
Okay, I'll have to
I
go
can
back and
follow
look
up with
at
the
mine.
commissioners with sending out the email that was sent out previously.
Okay. Unless there's something else, we'll see you in June. This meeting's adjourned.
Thank you.